And we will proceed with arguments in the case of Diane Moore versus Angela Moore. That's case number 17CA011171. Each side has 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. We are videotaping the proceedings, so please remain at the podium. If you could speak up, that is always appreciated. And the court has read the briefs, and we are ready to proceed if you are. Oh, yes. Thank you, Judge Carr. Judge Carr reminded me that one of the rules of the court is that if there are children involved, we don't state their names. Since this is being recorded, just use initials. Thank you, Judge. Yes, you may proceed. Let me know if you want to reserve any time as well.
Thank you. May it please the court. Those present. I would ask you at the beginning is to reserve 5 times for 5 minutes.
5 minutes?
Time for
okay. Very good. Thank you.
Thank you. Good morning, Your Honors. Attorney Brandon Oliver on behalf of the appellate, Diane Moore, who is the paternal grandmother in this matter. The case before this court deals with a grandparent visitation pursuant to Ohio Revised Code 3119.11. Tragically, in this matter, father of these minor children has deceased, which has brought about the motion that gets before the court this morning. I do not believe that there's any dispute to the section of the revised code that we're under. In review of the appealee's document, I believe we both agree, in fact, that what we're dealing with here is an analysis of the best interest factors under 3109.051D. The court stated they have read these briefs, and the argument herein today certainly deals with the belief that the underlying decision of the trial court was an abuse of discretion in the outright denial of any access to the minor children for the grandmother, Diane Moore. As stated, again, not disputed, father in this matter was deceased. That took place in 2011. This matter was initially filed with the court by grandmother on or about May 13th of 2016. And the hearing that is appealed from today, or the initial decision, goes back to July 19th, 2017. So effectively, grandmother's not seen these children in about 2 years. Actually, just over 2 years at this juncture, about 25 months. Now, clearly, as in many cases, we don't dispute every single factor of the 16 factors here. In fact, as the trial court indicated in their adoption of magistrate's decision, many of the factors were not relevant. However, of those factors that we dispute, one of them certainly goes to the weight that should be given to the relationship or the prior relationship between grandmother and minor children. In this case, like many other under this section, deal with one party being deceased. So this is the grandparent of the deceased parent. Grandmother, as I believe the transcript and everything showed, was kind of the carrier of that torch for father and his family. She lived locally. She spent a significant amount of time with the grandchildren. I know in the appellate brief's response, at some points it said she wasn't around them very much during the marriage, but then certainly after the death of the father, at least monthly, she spent time with the children. The transcript testimony showed that she did activities with the children, including holiday, traditional things that the family took care of. It's not an exceptionally large family. There's a grandfather who didn't have very much contact. Most of that was ancillary to grandmother's contact. There's an aunt who actually appeared at the underlying court who's lived in Michigan for a number of years, and that's about the extent of any contact with that. So grandmother really carrying that torch really is exceptionally important as far as the best interests of these children. One of the major concerns that were addressed at court had to do with a statement made by grandmother. And effectively that statement is that your mother's the reason your father's not here. The father in this case did commit suicide. That statement took place around May 13th, 2016. However, it did not get disclosed to mother until May 27th of 2016. And interestingly, the transcript showed that mother found out about this because she was served with paperwork. Upon getting served with paperwork, she was somewhat surprised to find out there was an issue with grandma. Her testimony says that's really out of the blue. And then the oldest daughter, the oldest child, who was 13 at the time, said, oh, the other day grandma said this, and sometimes she makes some comments. No other children made any reference to this. It was even asked. There's a middle child who was 11 at the time. He never made any comment about any statements from grandma. Besides that, the other issues that seemed to be raised were a trip that grandmother made to a graveyard shortly after Dad's demise in 2011, and then also some text messages that grandmother had sent to mom in 2012. Both of those 4 more years in the past, grandmother continued to carry on a relationship after that fact. It seems that the court certainly relied on the health and safety of the children regarding grandmother's statement or grandmother's well-being, but there's nothing in the evidence to show any detriment. The children actually, was asked if the children were in counseling or had been engaged in counseling at the time of the underlying hearing, and that hearing took place 6 months after a filing. The children were not in counseling. Well, 2 of the children were not in counseling. The one child, the middle child, was in counseling, but he had been the entire time.
Counsel,
Yes, John.
when I'm hearing your argument and I'm thinking about this, I think of a divorce situation between 2 parents.
Absolutely.
And in regard to visitation and so forth. And one factor the courts look at is how the other parent talks about the other parent. And we've actually had cases where there's been no visitation or supervised visitation with an actual biological parent, legal parent, because of saying demeaning things against the other parent.
Certainly, Court, Your Honor, I understand that, and I believe that had this been some litany of issues, had mother even been aware of this, that had been so prevalent that perhaps that would make more sense in this matter. But again, until there was a filing, she seemed to be oblivious to it. 2 weeks after the fact that the statement was made, the children hadn't brought it to her. There's no indication that the children were bothered by this, that there was any...
Well, why would the children come and say, hey, so I understand you're responsible for Dad's death? That's...
Well, I think...
And they're of an age now that they probably are starting to realize maybe that this is just not something that you want to bring up.
Understandably, but again, I think it'd be appropriate for the children to say, if they were bothered by it, if something upset them, that sometime in a 2-week period that have said, hey Mom, Grandma said this, is this true, or this is bothering me, or I don't want to go see Grandma anymore, even if they didn't disclose the actual statement. None of that came through in any of the evidence presented, Your Honor. It was...
I'm sorry, Counsel, do children always disclose things that bother them or are harmful to them?
No, Your Honor, they don't. That's true. However, one of the children was actively engaged in counseling. The older child had been engaged in counseling because of the grief of loss of their father. So these are certainly children that had more tools than maybe the average child of that age, having gone through a counseling process and been given those tools and skills to utilize. And none of that seemed to arise in that time period.
The court seemed to find that the middle child was affected more so than the other two, than his siblings. Was there an increase in counseling sessions after the statement was made?
And the testimony did show that that child had remained in counseling throughout, and in fact that counseling at different points in time had to be adjusted for the middle sibling here in this trio. However, there's no testimony that there was any adjustments made as a result of this statement. That child actually made no disclosure at any point of any statement that Grandma made, and that was testimony again 6 months later. He had yet, at least according to any transcript that I reviewed, made any statement about what Grandma had said. So my understanding is that the counseling that had been issues throughout the history since Dad's death did not show any sort of direct correlation to interaction with Grandma and then additional counseling. Again, Mother's statement was she thought this was out of the blue. It was until she gets served certified mail that Grandmother's filing that she finds this issue. One of the other issues that I think was significant to the court, and I think kind of goes to the proof is in the pudding, has to do with the willingness of the parents or the parties to be able to work with an order. Some of the testimony at the time, Mother stated she didn't think visitation was appropriate now, that if there was visitation it should be supervised, and certainly for her reasons, her own, I can understand that and appreciate that. However, since the date of filing, there's been no visitation, there's been no contact, there haven't been phone calls. There's been nothing at all. I understand this court's limited in scope to what they're looking at evidentiary-wise, but in 2 years, all's been for naught. So there's been no time where it's come to where there is going to be that contact absent court intervention on behalf of grandmother to be able to see the children, because it just hasn't come to place. Not supervised, not phone calls for the holidays, zero contact. These children are effectively mourning now the death of their grandmother because for all intents and purposes she's completely out of their lives.
Counsel, did the court, if I'm right, I want to make sure the timing's correct, didn't the court have some evidence before it of, I say conduct, but I guess I mean verbal expressions after the filing, so during this 2-year time period you're talking about, that perhaps led or bolstered the court's reasoning? And when I say comments, I mean comments that were adverse, not very flattering to the mother of the children, things that might cause the court to say things aren't getting better, they're getting worse?
I believe, Your Honor, referring to in the transcript, the only thing that I ever saw was a comment to the paternal aunt at some point in time during a conversation during the pendency of the litigation, where the grandmother made a comment to the aunt in a conversation, and the aunt testified to that at the hearing. So I believe there was an adverse comment there. Again, that was from one adult to another adult. I think really as more of a venting in litigation there. She hadn't had any access to these children, so now she's lost her son, and now she's lost her connection to her son and her 3 grandchildren, and at that point it had been several months, and this is somebody who had these children for overnights, who was responsible for the traditions, the holidays, all of those things, birthdays. She'd take the children to Build-A-Bear Workshop, Chuck E. Cheese, things of that nature. I don't believe anything shows that, absence comment, quite frankly, that she did inappropriate activities. She seemed to do age-appropriate activities with the children. And again, I think that goes to the court's ability. They also found that they were unable to make an appropriate order. Grandma's engaged in counseling at the point in time of the hearing and had been engaged in counseling. This court's certainly aware whether the court wanted grandma to continue in that counseling, whether they wanted to have some transitional periods of time where there was some supervision, maybe some comfort from mother to observe or a third party to observe, to put restrictions on grandmother to say, you're absolutely forbidden to make comments like this. And I mean, grandma even addressed it at the trial. She understood that was a mistake. That was a lapse in judgment on her part. She certainly did not go in holding out a denial that took place, and she wasn't there trying to state to the court that was appropriate or that she should have spoke. That was a lapse in judgment on her part, 100%.
Counsel, you've got 4 minutes left.
Okay.
If you want to reserve that, that's fine, or you can continue.
And at this time, we reserve the remaining.
All right, thank you.
Good morning, judges. My name is Lynn Schwartz, and I may please court. I represent the appellee, Angela Moore. So, as counsel for appellant indicated to the court on June 11 of 2011, a tragedy struck this family, and everybody involved has suffered. Children have suffered, my client has suffered, and my grandmother has suffered. It's important, I think, for the court to understand the reason for grandmother's filing her complaint. It was not because she was being denied access to her grandchildren. It was because she sought a fixed schedule of visitation. The record shows that since the father's death, that the mother did work with grandmother. She was flexible. Grandmother would seek to see the children, and if the children had activities, my client would reach out and try to work it out. There certainly were many issues along the road, and it was bumpy. And the question for you to decide today is whether the trial court abused its discretion in denying grandmother's complaint for visitation. Counsel correctly identified the statute to be applied, which is 31-1911, which provides for grandparent visitation. and as well as 3109.051D, which provides the court with all of the factors that it is to consider in determining the best interest of the children. Also, underlying all of this is the case law stemming from Troxel v. Granville and Harold v. Collier, cited in the briefs, which concern the fundamental right of a parent to make decisions regarding the care, custody, and control of their children. Another important fact that I would like the court to consider is the undisputed fact that Angela Moore is a very good parent to her children and that she makes good decisions, and every witness in the trial of this matter testified to that fact, including grandmother. There's a theme I'm hearing from counsel's argument and reading his brief, that they're suggesting that there needs to be a harm to the children before something should not take place for grandmother. That there needs to be a detriment, there needs to be a harm. And my question to you, does Ohio law require that a child be harmed before the court will protect the child? The answer is no, Your Honors. Judge Carr, in response to your question, in divorce cases, you're right, they will restrict a parent's access to a child if there's alienation, if there are bad statements made. And they don't wait for the harm. They will try and protect children from harm occurring.
I think counsel was referring to factor number 7, the health and safety of the children.
Absolutely, and the health and the safety of the children was the paramount factor that the trial court was concerned with. The narrative regarding the children's therapy is not done. It was not done on the day of trial, and it is not done today. Counsel had indicated that grandmother has not seen the children since the date of trial. That's not in the record. It's not before the court, but the court might want to learn that all 3 children are involved in therapy and all 3 have various struggles. So I would like to respond to counsel's representation of the statement that was made to the children. It's a little more egregious than that, I think, because since the death of the son, the grandmother had taken the position and addressed my client directly that she felt that she was the cause of her son's death. Alarming as it was, my client continued to allow contact with her, but did supervise it. So she exercised some parenting there to protect her children, but supervised visits for a while, and then went back when things seemed to settle down. Although grandmother says she's been in therapy and says she has been improving, I question that when now 6 years later, she's not only just directing those comments to my client, but she's saying them directly to the 3 young children of this case. She's also saying them to her living daughter. And not only just the statement is important for you to know, but the hostile attitude towards my client, as expressed verbally to her daughter, saying that she has criminal evidence that she has in order to prosecute her. And this was just said during the course of this litigation, to answer your question, Judge Callahan. In my view, it has escalated since the death of the father 6 years later. Counsel talked about putting together perhaps an order with restrictions on grandmothers to sell. You shouldn't say these things. However, that supersedes the mother's right to determine what is in the best interest of her child. The law presumes that a fit parent makes decisions in the best interest of their children. The statute provides, and the law provides, that the court is to give special weight to the parent's desires and the parent's wishes. And that is what the court did in this case. It gave special weight to mother's wishes. It determined that the children were at risk due to grandmother's hostile attitude, due to grandmother's statements that she was making, due to the children's health and their mental condition. And also the court was concerned with grandmother's mental state. And with all of those concerns wrapped up in one, the court determined to allow mother to continue to make those decisions that she deems to be in the best interest of her children. If there aren't any further questions, Your Honor, I would rest on my brief.
Apparently there are none, so thank you.
Return.
Yes, sir, you have 4 minutes left for rebuttal.
Thank you.
Thank you.
The owners, please the court here. I understand that Paley would like to rest on Troxel. Troxel certainly setting the precedent for a parent and their fundamental right to make decisions. However, since Troxel, there's been significant law and legislation here in Ohio that understands while that parent's given special weight, as you see in Harold v. Collier, as you see in cases like Lang v. Lang, there are 15 other factors for the court to consider in making a determination. If the parent and the grandparent had been in agreement, there'd certainly be no need for litigation in order to decide an order. It's certainly accurate that the appellant, grandmother, wanted a fixed schedule. My life runs on a calendar. I'm sure all of your lives run comfortably on calendars, and with a fixed schedule, you're able to make plans, you're able to do things. That's not to say that there's no flexibility in that whatsoever, but I don't think that rises to a level of unreasonableness. I do address in my brief the case of Lang v. Lang, which is a 9th District Court decision, and I do believe it is very analogous here and certainly that would be considered. As judges are aware, in that matter, there were issues. There was a father who was deceased after a divorce. There were significant outbursts. There were outbursts by the grandparents at the mother directly in front of the children. The court still was able to find a way in that case to order some sort of contact in the best interest of the children. And I think that's what we have here. Nobody's contesting whether or not Angela Moore is a fit parent. That's not a requirement. That's not one of the best interest factors. That's not anything in the statute. Nobody's seeking to remove any custody from her. This is just a visitation or companionship schedule. This is the sole meaningful connection for these children to their father. That's it. That's what's left of him. Is a grandmother who has the memories of him to share with him his childhood. Nobody's left capable of doing that. The aunt who's,
The aunt just testified to her mother.
Who is a state away. Sure.
Right.
And in that testimony, in review of the transcript, you oversee that certainly there was some animus between mother and the aunt while she was growing up. Whether that has to do with the fact that the aunt had an alternative lifestyle to mother's church views, and maybe that was some issues growing up, I don't know. But even the aunt's testimony, realistically, when we look at that, didn't entirely follow suit. Grandmother presented cards that she'd gotten from her daughter and her daughter's wife over the years that showed a better relationship than the aunt testified to at that point in time. So realistically, understanding the weight of this for the children and what this means, we think that this is certainly the abuse of discretion that they've raised it to. We're not looking for a harm to occur, but for something to occur. There's no evidence presented there was any impact. We have children in this case that were 13, 11, and 5 at that point in time. There wasn't a GAL, let alone an in-camera interview. There was not even a motion that nobody moved to get these children to be spoke to be heard. Nothing in the testimony shows that these children seem to be off put, and that's certainly not
Well, that's something, that anybody could have requested, right?
That is true, Your Honor. Anybody certainly could request that, and I certainly appreciate that. But again, it didn't happen. These are certainly children I think old enough to be able to share those opinions.
But sometimes with children, stuff doesn't come out until they're older.
That's true as well, and again, we look to the record, the children's counselor, and mother presented no evidence of the children's counselors to state that there had been any harm, there'd been any need for counseling at that point. And And as counsel stated, after Grandma's been out of their lives for 3 years, now all 3 children are in counseling again. 6 months after filing, only one of the children was in counseling. That had been continuous. Grandma's gone, and now we have all 3 children in counseling. Certainly it'd be speculative and outside the purview of this court, but perhaps the complete absence of the father's family at that point has led to some of those issues. Again, that may be a different hearing for a different date, but certainly would raise some concern.
And with that, counsel, you are out of time. So I want to thank you both for your arguments here today. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision the day it's released. And as well, the opinions are posted on the Supreme Court of Ohio's website, so you're free to follow that website as well. Again, thank you for both of you for your presentations.
Thank you very much.